Hey everyone, welcome to today's Explainer. Look, if you're a small business owner here in Olathe, Kansas, you already know the drill. Running a successful company takes a ton of focus and dedication. But man, absolutely nothing derails that focus quite like the crushing headache of a workplace conflict. It's the worst, right? Today, we're unpacking an awesome resource from Bouse on a real game changer for navigating those exact disputes without tearing your business, or honestly, your hair, apart. So let me ask you straight up, how are you stuck right now? Seriously, think about it. How much of your precious time, your mental energy, and yeah, your hard-earned revenue is currently being completely drained by disagreements with partners, maybe vendors or employees? It is exhausting. But the great news is there is absolutely a way to break that deadlock and get back in the driver's seat. And spoiler alert, it doesn't involve stepping foot inside a courtroom. Okay, here's our quick roadmap for today. We'll be covering 1, the cost of conflict, 2, what mediation actually is, 3, the business benefits, 4, the mediation process, 5, the players and their roles, and finally 6, binding results and privacy. Let's jump right in. Section 1, the cost of conflict, the heavy toll of workplace disputes. The harsh reality here is that traditional court battles are brutal. Litigation literally drains your time, costs you a fortune, and destroys important business ties. When you go to court, you are basically signing up for wildly unpredictable lawyer fees, the public exposure of your company's dirty laundry, and timelines that just drag on indefinitely. It's a completely hostile environment that shifts your energy away from growing your business and forces you to put it entirely into self-defense. Moving on to Section 2, what is mediation? A collaborative path forward. Simply put, mediation is an alternative dispute resolution, or ADR, process. It's informal, it's totally voluntary, and it relies on a trained, neutral third party. Instead of fighting it out in front of a judge, experts at places like Bouse Mediation right here in Olathe provide a calm, private space where both sides can actually collaborate. The focus isn't on destroying the other guy, it's on finding an answer that genuinely works for both of you. Now, what kinds of issues can this fix? Well, it's perfect for a whole bunch of common small business disputes. We're talking employment claims, like firing, discrimination, harassment, messy contract problems with vendors, deep disagreements between business partners, and of course, money issues. Mediation is a total lifesaver for all of these, especially when folks are coming to the table in good faith to find an answer, rather than just trying to set some sort of public legal precedent. All right, Section 3. The business benefits. Why mediation beats the courtroom. Let's talk ROI. Look at this timeline. 1 to 2 days. That is massive. Think about it. A court case can drag on for months, literally even years, totally siphoning your focus. But mediation, it's remarkably efficient. The vast majority of these disputes are completely handled in just 1 or 2 days, allowing you to get right back to the work that actually matters. If we put them side by side, litigation is this combative win-lose battle. It wrecks relationships, it's super public, slow, and the costs are totally unpredictable. Mediation, on the other hand, is a team-based win-win collaboration. It's designed to preserve trust, keep your business matters totally private, and it usually operates on predictable flat or hourly rates. It's quite simply the pragmatic choice for keeping your business on track. Which brings us to Section 4, the mediation process, a structured roadmap to resolution. Okay, so how does it actually work? There are 3 main phases. First up is pre-mediation preparation. This is where you gather your docs and figure out your BATNA. What's BATNA? It's your best alternative to a negotiated agreement. Basically, your backup plan. Absolutely crucial that you know it. Next, you move into opening statements and ground rules set by the mediator. And finally, you dive into the exploration of issues and interests, which is where the real problem-solving begins. During that exploration phase, you're probably going to use something called a caucus. Some people call it shuttle diplomacy. It's basically a private, completely confidential breakout session between just you and the mediator. You know, if things get a little too heated in the joint room, the mediator separates the parties and literally shuttles between them. This cools the tensions immensely and helps uncover what each side truly needs to solve the problem, without the pressure of all that face-to-face posturing.
Next up, Section 5, the players and roles. Who does what in the room?
Now, here's a huge misconception. People think a mediator is just like a judge. Nope. A judge makes the rules, tells you what to do, and declares a winner and a loser based strictly on the law. A mediator, however, is a neutral guide. They aren't picking sides, and they're definitely not forcing a decision down your throat. Instead, they empower you and the other party to build your own lasting solution by exploring those underlying needs.
And honestly, pulling that off requires some serious talent. An effective mediator needs strict neutrality, incredible active listening skills, genuine empathy, and masterful process management. That is exactly why many top-tier mediators have rigorous credentials, like training affiliated with Harvard Law School or accreditation from organizations like CDR. They are highly trained experts at managing high-emotion conflict and keeping the discussion productive. But hey, the mediator can't do it all alone. You've got a role to play too. You have to show up honestly and in good faith, meaning you genuinely want to find a solution. You've got to come prepared, have the real authority to make choices, and be ready to listen closely without interrupting. Oh, and your lawyer? They can absolutely be there. But in mediation, your legal counsel is there as a supportive advisor to help you review agreements, not as an attack dog trying to argue a case.
And finally, Section 6. Binding results and privacy, security, and finality. If you're sitting there worrying about sharing sensitive info, don't. Mediation operates without prejudice, under super strict ethical codes of confidentiality. That means absolutely nothing you say, offer, or concede during mediation can be used against you later if you do end up in court. The mediator won't even share secrets from your private caucus with the other side unless you explicitly give them the green light. That incredible level of privacy, it creates the psychological safety required for honest, productive negotiation. So what happens when you finally reach a deal? Well, agreements made in the mediation process can be legally binding. Sure, the actual conversations are informal, but the result is ironclad. Once both parties sign that written settlement, it becomes a contract that a court of law can enforce. You get all the peace of mind and finality of a judge's decision, but you kept 100% control over the outcome the whole time. Which brings us to the big question to leave you with today. Is your next business dispute truly worth a full-blown courtroom battle? When you stack up the wasted time, the drained finances, and the ruined relationships of litigation against the fast, private, and empowering path of mediation, honestly, the choice becomes incredibly clear. Thank you so much for joining me on this explainer. Protect your business, protect your peace of mind, and we'll catch you next time.